Bismillahirrahmanirrahim. Moses, Judge Saiban, ladies and gentlemen. मेरा नाम जी रज़ा रहमान एडवोकेट है. मैं पार्टनर हूँ जी लेक्सीम अटर्नीज़ एट लॉ का. वी आर लॉ फर्म बेस्ड इन लाहौर और हमारा ज़्यादा काम कॉर्पोरेट कमर्शियल लॉ का है और लिटिगेशन भी हम करते हैं. एंड वी आर इन्वॉल्व इन अ लॉट ऑफ लोकल एंड एज वेल एज क्रॉस बॉर्डर वर्क इन पाकिस्तान एंड वी हैव लॉट ऑफ क्लाइंट्स ओवरसीज एज वेल. सबसे पहले जी मैं आई वुड लाइक टू थैंक दी जी ठीक है. Firstly, I would like to thank the Punjab Judicial Academy for giving me this opportunity to come and speak to you all and just give my input on the topic today, which is cases relating to disputes attracting the provisions of the Contract Act pertaining to liquidated damages, penalties, burden and standard of proof of damages. As we have now the Punjab Commercial Courts Ordinance 2021, which, as ladies and gentlemen, you're well aware that this defines a commercial dispute as any dispute, claim or counterclaim arising out of a contractual dispute where the value of the claim or counterclaim is 500,000 rupees or more, or such other value as the government may notify, related to or connected with any transaction of trade, business or commerce, excluding sale or purchase of immovable property. And उसमें वो दिया हुआ है कि कौन से who could be the parties to the dispute, and it includes domestic companies, foreign companies, firms, domestic companies, foreign companies, domestic company, foreign company, or a firm or a private person. So, it covers a whole set of, persons, plaintiffs, defendants, and 500,000 rupees these days is not a very, very large amount. So, we're going to have a lot of disputes coming in to these commercial courts very soon. So, and obviously, as you're well aware, that the Contract Act is our law, the law of Pakistan relating to contracts and disputes under contract. And of course, Contract Act is the law which deals with the award of damages for a breach of contract. Of course, you have the remedies of specific performance and injunction as well, but we're not dealing with that today. So let's go through what. So I would like to split this talk into three parts. The first part is to give a very brief overview of how the law of damages and liquidated damages evolved. And since we are a common law jurisdiction in Pakistan, this evolved from the English legal system, the English laws. So just to give a brief understanding, it will be very interesting because in the light of that, we can go through the Contract Act provisions, which are section 73 and 74, and examine the Pakistani law and the Pakistani law position on that. And finally, so that's the second part, the Pakistani law. First is the English law, the second part is the Pakistani law. And the third part is, as a transactional lawyer, I draft, negotiate, contracts. I've been practicing now for the last 22 years in Pakistan and a little bit overseas as well, briefly. And the important thing is, how we negotiate these contracts. And, through our experience, when I'm negotiating a contract on behalf of a client, I have a very fair idea of what the law is, what the law pertaining to liquidated damages is, how we're going to frame or draft liquidated damages clause in a contract. And but unfortunately in Pakistan, the problem is that you see a lot of these big companies, and when there's an inequality of bargaining power, and you have got these big companies who are drafting these contracts, and they are have these standard form contracts, and they put in exorbitant amount of penalty clauses in these contracts, and they and a lot of people just sign those because they don't read that, or inequality of bargaining power, they don't negotiate that, and these act as an intimidation at times on a party who is a relatively weaker party in a contractual relationship. So it is very important that these principles are defined, how these are drafted, and once these cases come to court, which I'm sure they've already come now because this law is about 2 months old, but in the future as well, when these cases come to the court, it's very important that the law is very clear. When the judges are adjudicating upon these cases, the law is very clear. There's certain defined principles of that, so that ultimately it results in a more sort of reasonable drafting of liquidated damages provisions in a contract in the future. And hopefully they should lead to that. When you have judgments coming in, you have plaintiffs who are claiming X amount, and the court is awarding a reasonable amount in accordance with the law. Ultimately it will lead to a better drafting by various lawyers when they're drafting these contracts for the big companies. So starting with the English law, the first part, and of course at the end, if we have any time left, I'll be more than happy to answer any questions that you may have. So starting with the English law, there's a long history of these penal clauses, penal bonds originating in the 15th, 16th century, and those were secondary to a main obligation in a contract. And then if the main obligation survived, these penal bonds were always held enforceable, and there used to be a lot of misuse of these penal bonds. Then moving on, 16th, 17th century in England, they circumscribed that. They sort of linked it to a breach of contract, and what the penalty was, they linked it to the breach of a primary obligation in the contract. And ultimately, the courts of equity came in England, and they ultimately brought in this whole concept of liquidated damages. What liquidated damages are, what you can specify in a contract. So this is how the English law evolved on liquidated damages. Of course, damages under English law in a contract could be normal damages, which are, you don't specify something in the contract, and the courts award damages to a person, restoring them to the original pre-contractual position, or what you call the reliance test or reliance measure, or the reliance principle. And this is very similar to Section 73 of the Contract Act in Pakistan as well. But the liquidated damages provisions, they were ultimately developed over a period of centuries, coming into the 1900s, and then this century they evolved, they developed, and ultimately certain set principles were that what would be a reasonable pre-estimate of a claimant's losses. They can put that in the contract, and the court held those to be enforceable eventually. You have cases, for example, Ashley versus Weldon, and a couple of cases, when exorbitant amounts were being charged or put in the contract for a breach of contract related to an actress. She was supposed to perform, and non-performance meant a high penalty. Courts clawed that back, said it was a penalty clause, it can't be liquidated damages. So various cases, and ultimately the current position on English law, and it is very interesting. For the last 100 years or so, since the 1800s or early 1900s till now, they have been grappling with this whole concept. They made it a subjective test based upon facts and circumstances, but it became very difficult to come to an objective sort of principle. What test is going to be applied eventually. And there are two very interesting cases, and I would like to mention it for two reasons, actually. The first is because these cases are very contemporary and it defined the principles. And the second was that one of the judges in this case, in the Supreme Court of England, was a judge called Lord Sumption. And the reason I mention on a more humorous side Lord Sumption is because Justice Jawad Hassan, who's Honorable Justice Jawad Hassan, who's behind these commercial courts, he's the brainchild behind that. Lord Sumption is a huge favorite of Justice Jawad Hassan. So I thought it appropriate to mention that, to pay homage to Justice Jawad Hassan. Because he's a great judge, very, very commercial-minded judge. One of the leading lights of the Supreme Court of England. He was a judge till 2018. So the Supreme Court of England, decided in these two cases, which were Cavendish Square Holding versus Magdesi and Parking Eye Limited versus Vivis Customers Association. These were two very interesting cases. Both dealt with, they went to the Supreme Court of England, Both dealt with clauses in contracts which the appellants challenged as being penalty clauses and excessive, exorbitant. One case related to a person who had, there was sale of shares transaction. Mr. McDessie agreed to a non-compete clause, and the contract provided that if he breached that non-compete clause after selling the shares to the appellant or to the plaintiff, he'll be liable to pay certain damages. The share price or the amount that he was supposed to be paid was going to be deducted. So he breached the non-compete clauses, and they deducted the amount. And the court held that this was absolutely fine. It was not a penalty because it was the legitimate interest of the plaintiff to protect himself. So he could put in that. The second case was very interesting, which was a parking case. I was just coming on Fane Road after quite some time, and I saw huge parking issues here. So I don't know how that's going to be solved. Of course, in England, they just immediately come and clamp your cars, if you park for overtime or whatever, and that's how they maintain that. This parking case was that it was a parking garage. It is very interesting, and it's a very small amount, but imagine the case went up to the Supreme Court of England. So the parking garage said, is a public parking garage, that you can park for a maximum of 2 hours. I think it was £7 per hour or whatever. And if you overstay after 2 hours, you're going to be charged £85 penalty. £85. So the person, whoever this person, Mr. Beavis was, that he went to the court and he said that, after 2 hours I should be paid the same, should be paying the same parking amount. But this £85, what is this? This is an exorbitant amount. It's a penalty. The court said no, it's not a penalty, because the legitimate interest of the plaintiff, it was a parking garage, had to be maintained for the simple reason one person can't just hog the parking space for the whole day. There are other people who also need to come and park their cars over there. So you can't, the legitimate interest of the public and the parking garage was to be protected. So the critical principle coming down to liquidated damages, the latest critical principle in English law, the objective test is that the true test of a penalty clause is whether the clause in question imposes a liability on the guilty party disproportionate to the interest of the innocent party. Disproportionate to the interest of the innocent party. So in every case, you will have to see the facts and circumstances of the case. What is the legitimate interest of the innocent party? What is the penalty clause being imposed on the guilty party or the party breaching the contract? Because breach, of course, is the trigger point for these penalty or liquidated damages clauses. So that provision is very, very important. And this will again depend on the facts and circumstances of each case. As I mentioned, in the parking garage, you're paying £5 per hour, and then after 2 hours, you have to pay, 15, 17 times that much of amount. So it might seem very exorbitant and extortionate. It might look like a penalty clause. But at the end of the day, the court held that it was not a penalty clause, because the legitimate interest of the innocent party had to be protected, and this was not disproportionate. So that is the English position, ladies and gentlemen. And let's come now, of course, to the crux of the matter, which is Pakistani law, which all you honourable judges will have to apply in adjudicating these disputes, these commercial disputes when they come to you. So Pakistani law, you have two main provisions, Section 73 and Section 74 of the Contract Act. You have Section 75 as well, but let's not get into that. Section 73 and 74 are the fulcrum on which damages for breach of contract, that's where they rest. That's where how the courts are going to judge a case. So 73, I'll just quickly go through the language of that, because it is important, and how the courts have interpreted Section 73. So it says that when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. So, naturally arose, and which was foreseeable, and which was also proximate as well. And it also states that such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. And there's also an interesting explanation is that on that. I've skipped over the next part, but the one explanation is in estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. So this is, when you're going for a breach of contract and you look at all the judgments of the superior courts, when you go through that, or even when you go in the civil courts or now in the commercial courts, you normally plead section 73 and 74 together, but the critical point is that section 73 usually kicks in or usually is pleaded when there is no express provision for liquidated damages set out in a contract. Sometimes you plead, even if there is an express provision, you do use both, seeing being the plaintiff what is advantageous to you. But typically it is when there is no express provision set out in for LD's liquidated damages in a contract. So on section 73, just quickly go through the principles which the superior courts of Pakistan have enunciated over the years. I think so. As I mentioned, damage that naturally arose in the course of usual course of things. And the compensation must be actual and not indirect, remote, or consequential. So you take out the indirect damages, you take out remote damages, and you look at what naturally arose, what was foreseeable, what was proximate. And I think here they've sort of used the tort principle as well a bit, foreseeability, proximity, but applied it to contract. But what was foreseeable, what was proximate? Ji. जी जी हाँ जी 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 हाँ जी सही है जी सर, मैं उसी पे 74 में मैं आऊँगा, बट आपका ये जो सवाल है वो 74 से रिलेटेड है, सेक्शन 74 से। बट उसका मैं थोड़ा सा आपको मुख्तसर भी बता देता हूँ कि वो फैक्ट्स और सर्कमस्टांसिस पर डिपेंड करेगा, फैक्ट्स और सर्कमस्टांसिस पर डिपेंड करेगा। और एक बड़ा इंटरेस्टिंग केस है स्पेस टेल का, जिसमें मैं अभी डिस्कस करूँगा रिगार्डिंग। नहीं 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 नो 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 नॉट एट ऑल, एब्सोल्युटली एब्सोल्युटली जी, बिल्कुल जी, एब्सोल्युटली बिल्कुल। लाइक स्पेशल डैमेजेस, वो देखिए वो मैं आता हूँ 74 पे कि आप क्या क्या उसको आप इंटरचेंजेबली यूज़ करते हैं। 74 की लैंग्वेज क्या है कि हाउ आउटडेटेड अनफॉर्चुनेटली दैट इज़, बिकॉज 140 साल पुराना वो आपका तकरीबन लॉ होने वाला है कॉन्ट्रैक्ट एक्ट। लेकिन वो बात आप बिल्कुल सही फरमा रहे हैं कि वो आप एकदम आपने डाल दिया, वो नहीं, आप इस तरह नहीं कि आपने डाल दिया और आपको मिल जाएंगे। वो कोर्ट्स ने कोई टेस्ट अप्लाई करने हैं, फैक्ट्स और सर्कमस्टांसिस को देखना है और उसके मुताबिक आपको देंगे वो डैमेज। जी सर, वेरी रेयर वेरी रेयर वेरी रेयर जी। मैंने जो भी हमारी टीम रिसर्च करी थी फॉर दिस लेक्चर टुडे, तो उसमें हमने फैक्ट्स देखे थे और उसमें एक बड़ा इंटरेस्टिंग केस है, वो मैं स्पेस टाइल वाला आपको बताऊंगा मैं, लेकिन उसमें भी उन्होंने कोई टेस्ट अप्लाई किया हुआ है, टेस्ट अप्लाई किया हुआ है, वो मैं आपको मैं आई एड्रेस दैट जी। वो तो जी होना चाहिए जी, वो तो एब्सोल्युटली लीगल नोटिस आप सर्व करेंगे, नॉर्मल तो वही होता है कि लीगल नोटिस आप जी 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 ऑफ कोर्स एब्सोल्युटली एब्सोल्युटली बिल्कुल जी। वो तो इवन फॉर अदर्स और एंड स्पेशली फॉर लिक्विडेटेड डैमेजेस दैट इज इम्पेरेटिव, दैट इज इम्पेरेटिव। ठीक है जी, सेक्शन 73, लेट्स गो थ्रू दैट बिकॉज दैट्स नॉट डीलिंग विद LDs, बट आई थिंक it's important because it comes into play with section 74 as well when these cases go to court. So usme is a very interesting case, one of the landmark cases, West Pakistan Industrial Development Corporation versus Aziz Qureshi 1973 SCMR 555। अब उसमें section 73 का उन्होंने बड़ा क्लियरली वो जी SEMR 555 जी 555 555 जी जी 1973 SEMR 555 जी। अब उसमें उन्होंने वही प्रिंसिपल थे सेक्शन 73 के जी कि कॉम्पनसेशन इज पेबल फॉर एक्चुअल लॉस और डैमेज कॉज, जो आपने बात की है। द लॉस और डैमेज मस्ट बी अप्रॉक्सीमेट result of the breach and foreseeable by the defendant. Foreseeability is very important. In estimating the loss or damage, the means which existed for remedying the inconvenience caused by the non-performance of the contract must be accounted for. Again, they've used the language from section 73. The underlying principle to calculate and award damages is restitutio ad integrum, which, as you know, lawyers and judges we are aware of, restituting the party back in the place. In other words, the court must award damages which commensurate to restoration of the claimant to the situation which would have prevailed had no injury been sustained, i.e. restoration to the original or pre-contractual position. So, you see, these are the principles when you have no LD, typically when you have no specific provision for liquidated damages, but it is important to bring that in account because often you may not have any, when you're adjudicating these cases, you may not have any LD provisions. So that's how these principles are to be applied. They're pretty simple, straightforward, and you know they've been enumerated various times by the courts of Pakistan. Now section 74, and sir, आपका जो सवाल था उस पर मैं ज़्यादा elaborate करता हूँ. अब section 74 कहता है जी कि इसकी जो wording है, when a contract has been broken. Now, you know, just a little preamble to that. Again, you know, this law is almost 140 years old. 1872 का जो Contract Act है, और बहुत इसमें the clauses or the language in that is quite archaic. You know, using words like penalty, etc. But you know, credit to our courts in Pakistan, they've done the best they can in interpreting that, and we'll come to that. But you know, for any person who's reading it, you know, for a law student who's reading it in the beginning, or a person who's very inexperienced, you know, उनके mind में होएगा कि जी वो penalty is allowed. But you know what penalty means in now the English law, which we, you know, from where we derive our common law system, or even penalty what is now interpreted by Pakistani courts. I think it's very different from the general meaning of penalty as it existed in 1872 when the Contract Act came into being. So it says that when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be the penalty stipulated for. तो इसमें एक contradiction है, और plain text में भी contradiction इसकी है. आपने जो पूछा था, अगर ऐसे केस में हम apply करें, तो कोर्ट्स का तो वही है जी कि reasonable compensation पे आएंगे, वो penalty पे वो जो आपने stipulate जो किया है, they are not going to accept that. You know, the courts have enumerated again and again in Pakistan on that. So what 74 says, the trigger for section 74 is the breach of contract. Trigger for section 74 is the, you know, as envisaged by its drafters, is the breach of contract. And then they use the word penalty, but then of course qualified that. I think when they drafted it, maybe they, at that time what the law was in England, I think they sort of qualified by that by reasonable compensation, what reasonable compensation is. So, and I think the courts in Pakistan over the years, they have used this whole concept of reasonable compensation, you know, to avoid in terrorem provisions, to avoid harsh, exorbitant, intimidatory provisions, you know, to avoid those being enforced. And they have sort of clawed that back. They've clawed that back, and they have put in reasonable compensation, you know, whether or not loss would have improved, although there's an exception to that case as well, whether loss was proved or not. But they have sort of put in reasonable compensation, breach of contract and reasonable compensation. That's how they have interpreted section 74. And there are very interesting cases in that. One of the seminal cases in that is the province of West Pakistan versus Misri Patel and Co. And this is 1969 PLD SC 80. And in that case, I mean, briefly, the facts was that Ms. Patel and co. They offered the government of Sindh to purchase 4,000 tons of broken rice or 2.5 mons or whatever. The government accepted the offer, but there was a penalty clause of 5% of the total value of goods in case Ms. Patel breached the contract. 5% of the total value of goods. The suit was dismissed in that case. Suit was dismissed by the High Court and the Supreme Court of Pakistan for the following reasons, and they put in some very interesting principles on that, I think, and those the courts have used as a basis subsequent cases, including, you know, the more recent ones. So first they said that Section 74 of the Contract Act does not recognize the difference that exists in English law between liquidated damages and penalty. You know, what I talked about the English law, you know, they took out the penalty concept at that point in time, you know, at the advent of the last century, and they linked it to liquidated damages. They said if the clause is penal in nature, it won't be enforced, but if it's a liquidated damages clause, it's a reasonable pre-estimation, and, you know, it is not disproportionate. As I mentioned, these two judgments in 2015 of Lord Sumption. So they just, you know, put it down to liquidated damages. Penalty was out, but the courts in Pakistan said we don't recognize that difference. But again, that was 1973. We have to move forward. You know, they said that under common law, a genuine pre-estimate of damages agreed upon by the parties is regarded as liquidated damages, a genuine pre-estimate. But a stipulation in a contract in terrorum is a penalty. So terrorum means, you know, harsh, exorbitant, intimidatory provisions, you know, those are penalties. So in that case, you know, although they were saying at one point that there is no distinction, but then they are saying that it's a contract in terrorum is a penalty. And they are saying a reasonable, you know, pre-estimation, we can allow that. Liquidated damages, we can allow that. तो आपकी वाली बात है वो 25 लाख वाला जो है वो पेनल्टी के उसमें जुमरे में मुझे लगता है आ रहा है. You can't, but it might depend on the facts and circumstances of the case as well. And I'll come to the Spacetel case very shortly. जी. जी 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 बिल्कुल जी ठीक है जी जी बिल्कुल जी हाँ जी बड़ा अच्छा सवाल है जी आपका. वो सूट के ऊपर रिकवरी होएगा और क्या होएगा आपका. ऑब्वियसली इस कानून के नीचे तो हमारे इमूवेबल प्रॉपर्टी के केसेस एक्सक्लूडेड है, बट जनरली टू आंसर योर क्वेश्चन मे डिपेंड ऑन द फैक्ट्स एंड सर्कमस्टांसेस ऑफ द केस एज वेल. वो 50 लाख लेके अगर एक दिन आपने डिले कर दिया है या लेट से 2-3 दिन डिले कर दिया है जी 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 ओके जी देखिए सर, अगर एक करोड़ की प्रॉपर्टी है तो 50 लाख मेरे ख्याल में कोर्ट माइट नॉट अपहोल्ड दैट. कोर्ट माइट नॉट अपहोल्ड दैट. इफ यू लुक एट दीस प्रिंसिपल्स, कोर्ट माइट नॉट अपहोल्ड दैट. लेकिन अगर 5 करोड़ की प्रॉपर्टी है और 10% आपने अर्नेस्ट मनी दे दिया हुआ है तो शायद अपहोल्ड हो जाए. जी जी तो वो टिपिकली वो सूट फॉर रिकवरी करेगा जी सिविल कोर्ट में, यही करेगा और क्या करेगा. वो रिकवर करना है बिकॉज अगर वेंडर होता उसने द पोजीशन वाज रिवर्स्ड, ही हैड द ऑप्शन ऑफ अ स्पेसिफिक परफॉर्मेंस. लेकिन इसने रिकवरी वगैरह अगर इसने इफ ही हैज नो इंटेंशन of paying the money and getting the property, तो recovery करेगा. But he wants to pursue the case further and try to go for a specific performance. If he has any money later on, then he'll go for a suit for specific performance, I suppose. Depends. जी 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 रिकवरी वही है जी. हाँ, अंडर द लॉ. हाँ जी, द क्रिटिकल पॉइंट इज अंडर द लॉ. अच्छा वही है एब्सोल्युटली. वही है सूट फॉर रिकवरी है, and as I said के depending on the, if you look at the principles of section 74, depends on what the facts and circumstances would be, what is, and I think the critical part will be the sale price on that, कि कितने मिल जाना है, कितना उसको, what are the chances of succeeding is, will be what the sale price will be, what the percentage of the earnest money will be as part of the sale price as well. जी 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 सही है या सही है सही है हाँ जी सही है जी सही है सही है ठीक है जी सर वो जी 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 हाँ जी एब्सोल्युटली जी एब्सोल्युटली जी जी हाँ जी सही नहीं मेरा नहीं ख्याल जी इमीडिएटली डूब सकता है जी, वो आपने सॉरी आपने वो सही फरमाया, लेकिन मेरा जो व्यू है, अगर आप वो पोजीशन आप मुझे पता है आप किन केसेस की बात कर रहे हैं, लेकिन उसमें ये है कि इट्स नॉट अ लॉस्ट कॉज, इट्स नॉट अ लॉस्ट कॉज बिकॉज फैक्ट्स सर्कमस्टांसेस डू कम इनटू प्ले जब एविडेंस रिड्यूस होएगा, आई थिंक और मेरा ख्याल है कोई प्लेंटिफ ये एडमिट नहीं करता है अपनी वो लाइबिलिटी की जी मुझसे डिफॉल्ट हो गई है जी हाँ जी हाँ जी सही एब्सोल्युटली जी एब्सोल्युटली नहीं आई एग्री विद यू जी, आई एग्री विद यू। देखिए जी कोई प्लेंटिफ एडमिट तो नहीं करेगा अपनी डिफॉल्ट, वरना वो जाएगा ही नहीं जी, बड़ा बेवकूफ़ होएगा, या फिर अपने वो वकील को फिर वो आई थिंक फारिग कर देगा, उसने कहा जी एडमिट कर लो डिफॉल्ट। हाँ जी एब्सोल्युटली हाँ जी एब्सोल्युटली सही बात है जी बिल्कुल जी। ये मैं मिस्ट्री पटेल वाले मैं आपको ज़रा बता देता हूँ जी, बड़ा ये ऑल्दो इट इज़ नॉट रिलेटिंग टू इमूवेबल प्रॉपर्टी बट ये इंटरेस्टिंग है, उसमें उन्होंने कहा था, उसमें एक और पार्ट भी आ जाता है जी, बड़ा एक और पार्ट भी आ जाता है, इंटरेस्टिंग है कि डिड रीजनेबल व्हेन यू टॉक अबाउट रीजनेबल कॉम्पनसेशन फॉर द डिफेंडेंट, अगर आपने 50 लाख का आपने एग्जाम्पल दिया है कि रीजनेबल कॉम्पनसेशन है डिफेंडेंट को, अगर आपने लिखा हुआ है वॉज दैट रीजनेबल कॉम्पनसेशन और नॉट, वॉज दैट रीजनेबल और वॉज दैट एग्जॉर्बिटेंट। And the second part, when you look at evidence, as was the case in मिस्त्री पटेल, और ये अक्सर होता है रियल एस्टेट में भी, उसमें उन्होंने उसे उठाए नहीं थे, गवर्नमेंट ने किसी और को बेच दिए थे, एंड दे अर्नड अ प्रॉफिट ऑन दैट, दे अर्नड अ प्रॉफिट ऑन दैट। वो ये राइस के थे जो बैग्स वगैरह जो भी थे, सो उसमें पेनल्टी क्लॉज था, उन्होंने इसने उठाए नहीं, उन्हें किसी और को बेच दिए, प्रॉफिट कमा लिया उसके ऊपर, द कोर्ट रिफ्यूज टू इन्फोर्स दिस पेनल्टी क्लॉज। सो सवाल ये है कि इन फ्यूचर केसेस लाइक दैट कोई थोड़ी DHE की प्रॉपर्टी होए तो वो आजकल मार्केट वैसे ही गर्म हैगी तो वो किसी और को बेचते हैं एंड मे बी सेल एट अ प्रॉफिट, यू नो दीज थिंग्स माइट बी टेकन इनटू अकाउंट। आई मीन ये सारी इट्स नॉट, आई डोंट थिंक इट्स अ लॉस्ट कॉज, आई डोंट थिंक इट्स अ लॉस्ट कॉज एब्सोल्युटली। तो ये मिस्ट्री पटेल का जी बड़ा इंटरेस्टिंग था, ये जो आपको प्रिंसिपल्स बताए हैं। वेदर और नॉट डैमेज वॉज, मतलब उन्होंने एक बात कहा कि जी वेदर और नॉट डैमेज वॉज प्रूवन और नॉट, उन्होंने लिया, बट उन्होंने उस केस में दे डिड नॉट अवॉर्ड बिकॉज देयर वाज प्लेन एग्जांपल दैट देयर वाज नो लॉस व्हिच accrued to the government of Sindh at that time. They made a profit on that and the court said that this penalty clause was not enforceable. So ये बड़ा इंपॉर्टेंट चीज़ आ जाती है जी कि एंड द इम्पॉर्टेंट थिंग, अच्छा एक और चीज़ इसमें ये है कि व्हेन यू आर adjudicating upon these cases, you know, and when section 74 is brought into play, it will depend on the party, on the plaintiff, what is more suitable for him. But 74 can often prove is useful, but can often prove fatal for a plaintiff as well, for the simple reason that you can't award more than what has been specified in the contract. So उसका अगर loss भी ज़्यादा हो गया है अगर 74 into play, the first thing defendant is trying to claim more than what is specified in the contract. The first thing defendant will say is section 74 आपका आ रहा है, it's not वगैरह, तो it could जी एब्सोल्युटली जी 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 जी